Tonight, the chairman of the House Judiciary Committee, the day after Robert Mueller's testimony to that committee, says that the next step for the committee is to hear from the most important witness in the Mueller report, the witness who delivers the most damning evidence of Donald Trump's obstruction of justice and crimes, former Trump White House counsel Don McGahn. Here's Chairman Jerry Nadler tonight on MSNBC.
The American people have to hear directly, for example, from Don McGahn as to, and he has to testify in front of Congress, so that he can say what the president said to him, what illegal instructions the president said to him. We have to hear from other witnesses who testified to Mueller, but we need to hear, and the American people need to hear their testimony directly. This has been blocked, and we're going to court to unblock it.
Chairman Nadler says committee lawyers will be in court tomorrow, seeking to enforce their subpoena of Don McGahn as a witness. Don McGahn's name appears in the Mueller report more than 500 times, and several committee members asked Robert Mueller about Don McGahn yesterday.
Your investigation found that President Trump directed White House counsel Don McGahn to fire you. Isn't that correct?
True.
The president told the White House staff secretary, Rob Porter, to try to pressure McGahn to make a false denial. Is that correct?
That's correct.
So it's accurate to say that the president knew that he was asking McGahn to deny facts that McGahn, quote, had repeatedly said were accurate, unquote. Isn't that right?
Correct.
Congresswoman Val Demings had two opportunities with Robert Mueller yesterday, first in the Judiciary Committee and then in the Intelligence Committee. Here's what Congresswoman Demings asked in the Judiciary Committee.
Lies by Trump campaign officials and administration officials impeded your investigation.
I would generally agree with that.
Later in this hour, you will hear Joyce Vance identify that question as the most important question of the day and explain why and explain how that question links Volume 1 and Volume 2 of the Mueller report. And here is what Congresswoman Demings asked later in the Intelligence Committee hearing.
Director Mueller, I too want to focus on the written responses that the president did provide and the continued efforts to lie and cover up what happened during the 2016 election. Were the president's answers submitted under oath?
Yes, yes.
What did you determine about the president's credibility?
And that I can't get into.
Well, let's go through some of the answers to take a closer look at his credibility, because it seems to me, Director Mueller, that his answers were not credible at all. Do some of President Trump's incomplete answers relate to Trump Tower Moscow?
Yes.
Did the president answer your follow-up questions? According to the report, there were follow-up questions because of the president's incomplete answers about the Moscow project. Did the president answer your follow-up questions either in writing or orally? And we're now in Volume 2, page 150 through 151.
No.
He did not. In fact, there were many questions that you asked the president that he simply didn't answer. Isn't that correct?
True.
And there were many answers that contradicted other evidence you had gathered during the investigation. Isn't that correct,
yes.
Director Mueller? Director Mueller, isn't it fair to say that the president's written answers were not only inadequate and incomplete because he didn't answer many of your questions, but where he did, his answers showed that he wasn't always being truthful?
I would say, generally.
Leading off our discussion tonight is Democratic Congresswoman Val Demings of Florida. She's a member of the House Judiciary Committee and the House Intelligence Committee. Thank you very much for joining us tonight, Congresswoman Demings. I really appreciate it. I know it's been a busy week.
It's good to be with you, Lawrence. Thanks for having me.
And I want to go to what we just saw you questioning Robert Mueller about, and that is reminding us all that the president did submit to written questions and answering written questions. But as you illuminated, he did, to put it mildly, a terrible job of answering the written questions.
He did a terrible job. And let's start with Director Mueller not being able to comment on the President of the United States' credibility. And then his answer regarding the written questions. And we do know the president refused to do a sit-down interview. Director Mueller tried to get him to do that for a year. He refused. But then, obviously, in his written answers, he was not always truthful, as Director Mueller indicated.
And the Mueller report does comment on the credibility of other witnesses, comments favorably on the credibility of witnesses where it finds them credible. And so Robert Mueller could have, if he found the president's written answers credible, said so.
I think it's reasonable to assume that if, as you've just indicated, if the president thought, or if Director Mueller thought the president was credible, he certainly would have said that. He even commented about the credibility of Gates and Michael Cohen, saying that after thorough vetting, he was able to find their testimony about WikiLeaks credible, but he wasn't able to comment on the president's credibility.
Bringing all of your years of law enforcement into what you heard yesterday, what is your assessment of the criminal liability of Donald Trump?
You know, yesterday, Lawrence, was actually a very painful day. Well, you know, what Director Mueller confirmed was that Russia interfered. The president didn't seem to care much about that. Matter of fact, he loved it. He welcomed it. And that he engaged in multiple instances of obstruction of justice to impede the investigation into Russia interference. The section about Don McGahn, where the president repeatedly asked him to get rid of the special counsel and then called him multiple times, asking him like a mobster if it had been done. Yesterday was a painful day, but it clearly indicates why Director Mueller was unable to exonerate the president or find him innocent, basically, of any wrongdoing.
You brought up the point that with the written questions, they had follow-up questions after they'd seen the answers, especially since the answers were incomplete. Some of them they just didn't answer at all. And then the president didn't answer any follow-up questions.
According to Director Mueller, he was strong there. He said, you know, to a direct question, did he answer any of your follow-up questions? No. And if you read the president's responses, over 30 times, the president said he did not recall or remember key instances or key conversations during the case. So the president, I clearly understand after listening to Director Mueller why he was unable to exonerate the president.
In your career in law enforcement, you've seen cases that are slam dunks. You've seen cases that are close calls, not sure. Should we charge? Should we not charge? What do we have here? You've seen cases get dismissed in court, and not been surprised, and then sometimes surprised, because you understand the various weights that evidence can have. What's your assessment of the case against the president that Robert Mueller has assembled in this report?
Lawrence, when the report first came out and I had an opportunity to read it, and remember, as a member of both committees, I've had an opportunity to read the unredacted version as well. But when I first read the redacted version, I was convinced then that the elements of multiple crimes was there and that we should have begun impeachment proceedings at that time. Certainly after reading the unredacted version and just everything being topped off with Director Mueller confirming some very critical portions of that report, I have no doubt in my mind, as a 27-year law enforcement officer, a police detective, and a police chief, that the president engaged in wrongdoing, and were it not for the Department of Justice OLC opinion, he would have been indicted.
Is it only members of the Intelligence Committee who've been able to see the unredacted version?
I'm not sure about that particular portion. I do believe there are some limited members of the judiciary, like the chairman, but I know members of the Intelligence Committee have been able to review it.
Could you give us some sense of how much more people would understand if they were able to see the unredacted version?
Well, the unredacted version really has more to do with identifying information. And sometimes when you know who is involved, it really helps you to better be able to piece the pieces of the puzzle together.
Would you say the unredacted version would add to possible impeachment charges against the president?
Remember, I've thought for a long time, for 4 months now, that there was plenty evidence in the redacted version to begin impeachment proceedings. But every bit of information, every bit of evidence certainly helps us get to the point where we need to be.
Congresswoman Val Demings, thank you very much for leading us off tonight. Really appreciate it.
Thank you.
And the question that I was most looking forward to in yesterday's hearing was asked by Congressman Sean Patrick Maloney.
Why didn't you subpoena the president?
We were almost towards the end of our investigation, and we'd had little success in pushing to get the interview of the president. We decided that we did not want to exercise the subpoena powers because of the necessity of expediting the end of the investigation.
What did you think of the president's written responses, Mr. Mueller?
Certainly not as useful as the interview would be.
By my count, there were more than 30 times when the president said he didn't recall, he didn't remember, no independent recollection, no current recollection. And I take it by your answer that it wasn't as helpful. That's why you used words like incomplete, imprecise, inadequate, insufficient. Is that a fair summary of what you thought of those written answers?
That is a fair summary. And I presume that comes from the report.
And yet, sir, and I ask this respectfully, by the way, the president didn't ever claim the Fifth Amendment, did he?
I'm not going to talk to that.
Nobody told you you couldn't subpoena the president, is that right?
No, we understood we could subpoena the president.
So my question, sir, is did you have sufficient evidence of the president's intent to obstruct justice, and is that why you didn't do the interview?
There's a balance. In other words, how much evidence you have to satisfy the last element against how much time are you willing to spend in the courts litigating the interview with the president. The reason we didn't do the interview is because of the length of time that it would take to resolve the issues attendant to that.
Turning our discussion now is Democratic Congressman Sean Patrick Maloney of New York. He's a member of the House Intelligence Committee. Congressman, first of all, thank you very much for asking the question that I wanted to ask. But it was such an obvious question. I was sure someone was going to ask it. Do you feel it was answered? Do you feel you now know why they did not subpoena the president?
Yes, I sure wish they had, though, but I think it's very important to listen to what the director said. And what he said was that, and by the way, they wrote this in Appendix C and on page 13 of Volume 2, that they had significant and substantial evidence of the president's intent to obstruct justice. And they cite a bunch of cases where, those cases point out that you frequently show intent to obstruct justice without an interview of the investigatory subject. That's often how it works, because people don't admit that they were trying to obstruct justice. And in those cases, it's more than enough to infer that intent with other evidence. And when you say you've got substantial and significant evidence of the president's intent, my point was simply that they're telling us on those pages that they thought they had enough.
Yes, and I had found that use of the word intent, and I have to say it surprised me when I landed on that use of the word intent, because how would you establish intent without talking to the witness? But as you point out, they believe that they had so much information that it clarified intent. But the report does not then say what the intent was, and Robert Mueller didn't say that yesterday.
Well, that's because, remember, the special counsel is basically in a box. He can't prosecute the president, and he said that fairness concerns would prevent him from accusing the president of a crime without giving the president the opportunity he would have to defend himself in a normal situation where he was charged with a crime. Therefore, this is the most you can do. In other words, you could forgive the special counsel for laying it all out on 10 different instances of obstruction, saying he had sufficient evidence without an interview of the president's intent, a key element, and then believing that the Attorney General would care about that and wouldn't lie about it to the American public or dissemble or hide it for weeks. And by the way, that the Congress would care. I think he told us everything he could tell us under the department's rules and under the fairness concerns they were operating under.
Yeah, and those department rules that prevented him from discussing deliberations, that was an enormous thing to leave out, because you could have gotten, if you could have discussed the deliberations, you could have asked him about the discussions within the office about this decision to not issue the subpoena. But what about the part of his answer where he said we basically just didn't want to take the amount of time, given that there was no time limit on the investigation. Why would he be concerned about the amount of time it would take to enforce that subpoena?
Yeah, I think that's a hard question, and I'm disappointed that they didn't take that time. I served in the White House when a president was put under oath for hours before a grand jury on videotape under oath, and that was because the independent counsel had subpoenaed the president. That was President Clinton, and that was the moment when the American public had to see him answering tough questions under oath. We should not have been deprived that moment of this president. Donald Trump should have been put in a chair under oath and asked some very tough questions, and I regret that very much. But I want to say that respectfully, because I do believe here the special counsel was telling us something important, which is that he had substantial and significant evidence. Those are his words of the president's intent to obstruct justice, and they lay it out chapter and verse. And he was under constraints that previous counsels were not under. And so, in a sense, this was the best you were going to get.
Yeah, and the big distinction, he was not an independent counsel like Kenneth Starr. He was a special counsel. And unfortunately for Robert Mueller and his team, that meant that they could all be fired at any time. And there was the president of the United States, in effect, publicly threatening to do that. Then there comes a day in Don McGahn testimony where they discover the president has already a couple of times ordered Robert Mueller to be fired. And one of the questions I was wondering about, which no one quite got to yesterday, but maybe in further investigation it'll come out, was Robert Mueller or anyone in the Mueller team concerned about the possibility of being fired by the president? And if they were concerned, did that affect the speed of their investigation? Did that, in effect, speed them up? Might that explain why Robert Mueller felt there was, in effect, a time limit with the threat of being fired by the president?
I suppose that's possible. And there was, remember, a brand new attorney general coming online.
Yes.
And they worked for that attorney general, as you point out. Right. And so the attorney general was confirmed, I believe, in early March, I want to say, and the report was done just about 2 or 3 weeks later. So I think there were definitely a lot of things coming together at that time frame. But honestly, and again, respectfully of Mr. Mueller, because I have enormous respect for him, it was 16 months after his appointment that they got written answers. And those written answers were, by his own language, incomplete, imprecise, inadequate, and they were getting rope-a-doped by the president's lawyers for months and months. They had to know. They were never going to get anything truly useful out of those answers. And so there was always going to have to be a subpoena and an in-person interview. And I guarantee you that the president's lawyers were surprised that they didn't have to give one of those. And I just think it's one of the great missed opportunities of this investigation, because we'll never see this president sitting in a chair under oath answering the tough questions. And I sure wish we had had that opportunity.
I could do this with you all night. The one other point I'd make is that Robert Mueller specifically did not answer the question of, was the president going to invoke the Fifth Amendment? So if they had a Fifth Amendment conversation and Mueller and company knew that even if they enforce the subpoena, Donald Trump will sit there and take the Fifth Amendment to every question, that could be another reason not to do the subpoena. But so much more investigative work for you to do on this.
Well, there are some serious unanswered questions, and I think it definitely underscores the role that Congress needs to play, given the constraints that the special counsel was under. We've got work to do.
Congressman Sean Patrick Maloney, very good work yesterday. Thank you very much for joining us tonight. Really appreciate it.
My pleasure.
Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.